Thanks for joining today's webinar. My name is Brian Ness, helping facilitate the webinar today. A few housekeeping items before we get going. If you have any questions, feel free to use the Q&A and chat feature, and Jim Nelson will answer those at the end of today's presentation. Also, I'll be sending out a recording of today's presentation and the slides tomorrow morning. For today's presentation, Jim Nelson is going to be talking about the evolving law regarding opinions, in particular the HALO decision. Jim, I'll let you introduce yourself and take it from here.
Well, good morning to those of you on the West Coast. Good afternoon to those of you on the East Coast. And I hope all of you in the Midwest are having a great time with this wonderful weather of ours. So opinions. What is an opinion? An opinion, we all have opinions about practically everything. And if you are in a technical field, and especially if you are in a technical field where you or your employer obtains patents, you've read patents, and you have an opinion about them. And of course, we all know that patents have claims at the ends. If you're an engineer, if you're a scientist, if you are an accountant at a company, and somebody asks you about a patent, you'll have an opinion about it. As an engineer or a scientist, you'll read those claims and you'll say, oh, you don't infringe those patents, and that's the end of it. Well, that's great that you have an opinion like that, but in order legally to have an opinion that does a good job of protecting you and your company against certain untoward and difficult aspects of the law, you need to have a competent opinion. So let me talk a little bit about the history regarding opinions. Back in the beginning of time for the Federal Circuit, back in the early 80s, the Federal Circuit wrote an opinion, underwater devices. You see it here on the first slide of the PowerPoint. And in underwater devices, the Federal Circuit stated that at that time, the early 80s, late 70s, early 80s, people did not respect patents. People were infringing patents all over the place. Patents were found invalid, more than valid most of the time during litigation. And so the Federal Circuit said, enough already. There is a patent statute that says patents are presumed valid. And so they wanted to take steps to make the world understand that US patents have a presumption of validity. So what the Federal Circuit said in the early 80s is that if you do not obtain an opinion that you don't infringe or that the patent is invalid, and the opinion is a competent opinion, and that opinion is obtained before litigation, then if you don't have something like that, during the litigation, the patent holder, that is the plaintiff, can assert an inference that you did this infringement in bad faith. Now, what does that mean, bad faith? If you've infringed a patent in bad faith, it means that you are subject to treble damages. And you can imagine if the damages are on the order of $500 million and now they're tripled to $1.5 billion, that's a significant hit for your company. Even if it's $100,000 and it's tripled to $300,000 for a company that has a yearly profit of $100,000, that's tough going. Well, the result was everybody was obtaining opinions, and they obtained opinions left and right and upside down and backwards and forwards, all before litigation. Back in the heyday of opinion drafting, back in the 80s, we would do searches, we would do FTOs, freedom to operate reviews, we would write opinions, and to a large extent, those opinions set the stage for subsequent litigation. Well, along about 20 years later, in the late 1990s, the Federal Circuit issued a second opinion regarding opinions. That's the Nor-Bremse system for Nutzfahrzeuge. In other words, fire extinguishers. This is the famous fire extinguisher case that was written by Judge Newman, and she said that looking at the past 20 years, it's clear that the public now respects patents, and validity of patents is respected, and so that the Federal Circuit decided that they should revert to the usual view regarding inference of intentional infringement. In other words, if you did not have an opinion, a formal, competent written opinion, but had testimony of good faith, belief that the patent was not valid or the patent was not infringed and it was reasonable, that the almost required inference of intentional infringement could not be made. All right, so that's the fire extinguisher case. Then subsequently, another 10 years later, along came the Seagate case, another Federal Circuit case. And in this one, the Federal Circuit raised the bar, raised the burden for the plaintiff to prove a willful infringement so high that it became almost impossible to show willful infringement. Well, the Federal Circuit established this two-part objective test for knowing infringement, and those two prongs of that test were triggers to enable the plaintiff to ask for treble damages and show willful infringement. Well, that managed to set the opinion practice on its ear. Nobody obtained opinions after that because what the need? It was almost impossible for plaintiffs to show that there was willful infringement based on this two-pronged test. Along came the Halo case, and of course the Halo case went through all of the court proceedings and went through the trial courts. It went to the Federal Circuit, got to the Supreme Court. The Supreme Court then took a look at Seagate and said, Seagate didn't make sense. They said that under the Seagate standard, someone who plunders a patent like a pirate, infringing it without any reason to suppose his conduct is arguably defensible, can nevertheless escape any comeuppance under Section 284 solely on the strength of his attorney's ingenuity. Well, that's a plus for attorneys, but it doesn't say much for the defendant. So the Supreme Court said in Halo, culpability should be measured by what the actor actually knew at the time of the challenged conduct, not by facts that the defendant neither knew or had a reason to know at the time he acted. So as a result, the standard, the basis for showing willfulness, showing recklessness, drops significantly. Now, all of this discussion concerns what's needed to show reckless disregard, show willfulness under the patent statute, 282 and 284. And what I am planning to talk about in the rest of this discussion is what this means for opinions. And of course, the other big holding in the Halo case is the fact that in this situation, the defendant only has to show by a preponderance of evidence standard, not clear and convincing evidence, a preponderance of evidence standard, that he has done a good and competent job of avoiding infringement. So in this instance, Halo has really created an evolution, a reverse evolution, I would say, for opinion drafting. So there are a number of ways you can infringe a patent. Of course, there's contributory infringement, inducement infringement, and of course, direct infringement. And each one of these, the answer to the question, has Halo changed evolution, changed the direction of this history of case law from not needing an opinion to needing an opinion? The answer is yes, very clearly. So for contributory and inducement of infringement, the plaintiff needs to prove knowing infringement, because knowledge is a part of the legal requirement. It's part of the statute for contributory inducement infringement. And competent opinions constitute significant evidence of a good faith effort not to infringe valid patents. If you are able to do that, then you avoid the willfulness charge that leads to triple damages. For direct infringement also, it's the same situation. Post-Halo cases in the trial courts indicate the same kind of reasoning. So, for example, commentators throughout the last 2 or 3 years have indicated that opinions prepared pre-litigation will provide significant evidence of a defense of willfulness. So here are 2 very contrasting kinds of cases, the Great Bach case and the Omega patents. And in the Great Bach case, the defendant lost the litigation, but the defendant had a timely obtained and reasonable analysis of an opinion that he did not infringe the claims of the patent. And this was a complete defense against the charge of willfulness, even though the defendant, AVX Corporation, lost litigation. The contrast is this case from Florida, where the defendant asserted during the litigation that the patent was invalid, but the defendant had no opinion and no discussion and not even any emails or memos about the fact that the patent might be invalid before the litigation started. And so the court wrote this statement: absence of a formal opinion before litigation demonstrated that defendant had no knowledge of its patent invalidity defense at the time of infringement. So in this case, here is the defendant knowing about the patent, had no defense, and went ahead and infringed it, made the products falling under the patent anyway. What would you think about this? Of course, it's willful infringement. He had no excuse. And so the result was increased damages for willfulness. So practical results for evolving law and opinions. And as I said, in the 1980s through the 90s, that was the heyday for opinions. You always needed outside counsel for non-infringement, for invalidity, for FTO clearances and surveys. From 2004 onward, outside counsel opinions before litigation are a very good idea. And inside counsel review is okay, but in these days, especially with those recent court cases involving situations where inside counsel, of course, has a bias and is under scrutiny from the upper management to come up with the quote correct opinion, there is some suspicion on inside counsel, so that inside counsel needs to confirm, especially in situations involving potential for litigation, needs to confirm the ideas, confirm the analysis regarding non-infringement and or invalidity in situations like this. So inside counsel can provide reasonable reviews, but in situations where the inside counsel thinks that there is a danger, that there may be litigation, it is a good idea to seek independent review by outside counsel. The outside review of independent counsel will avoid allegations of bias, suspicion of pressure from upper management, and all those things that inside counsel can be subject to. Now, the patent owner also needs to think about opinions, and this may be a surprise to some of you in the audience, but yes, the patent owner needs to think about these situations, because the patent owner has the requirement of proving infringement, and the patent owner cannot just launch willy-nilly a litigation without doing an investigation concerning whether or not the patent is infringed. The patent owner needs to find out what the products are, needs to find out what the details of the products are, and needs to compare them with the patent claims in order to come to a conclusion that yes, the patent owner thinks that the patent is infringed. Why does the patent owner need to do this? Because of Rule 11, Federal Rules of Civil Procedure 11, that bringing a frivolous lawsuit subjects the patent owner to increased damages and other penalties. So lack of an opinion, as I say, Lack of opinion puts the defendant in the danger zone, but unlike the situation from the 80s, it does not necessarily lead to an automatic willfulness result. So the bottom line, get an opinion before litigation begins. Well, we're all talking about litigation here, and aside from litigation and treble damages and expensive opinions like Judge Breyer in the Halo case wrote in his concurring opinion, he apparently was castigating opinion lawyers for writing such expensive opinions because Judge Breyer or Justice Breyer indicated that a competent opinion is what is needed, not necessarily a highly expensive opinion from outside counsel. Nevertheless, aside from litigation, aside from treble damages, aside from all this reasoning and analysis concerning willfulness and recklessness and pirating and all these things that go into the legal analysis of willfulness, what are some practical reasons for opinions? And of course, wholly aside from all this, if you're a company or you're making a development in your garage and you're a solo practitioner, a solo inventor, you're investing time, effort, and money in all this. And it takes years to develop a commercial invention. In the pharmaceutical area, for example, the typical time for bringing a product to market is 8 to 10 years. And the expense is on the order of billions of dollars. For the software market, software development is not so long and it's not so expensive, but nevertheless, there are a huge number of employees you have working on the software programs. And in this day and age, it does get to be quite costly. It is a shame, and actually your CFO is going to make it more of a penalty than a shame to have spent all that money, time, and effort and research development only to find that there's a patent out there that blocks your product. That's not smart. So what do you need to do? You need to run a freedom to operate, and you need to run this several times during the product development. You need to conduct a search when the researchers have an idea and a goal and a route to get there. You need to run a search to see if there are third-party patents in this area. Once the product parameters are identified in even a broad way, you need to go back and review that search, see if there's anything else you need to do, and investigate the patents that do seem to be relevant. Once the product proof of concept has been made and the product looks like it is a go, that's where you need to run the freedom to operate review and develop a report about the patents that you find that are highly relevant. If there's one that you do think is a block, you need to do a deep dive into the infringement analysis, and you need to consider design arounds to help the researchers figure out how to avoid infringement. And of course, in design around for a product patent, a pharmaceutical product patent is a lot more difficult than a design around for a formulation patent involving excipients, a software patent on a particular kind of software program, which of course is problematic these days with Alice and 101, but nevertheless, if you're able to make your way, if the patent owner is able to make his way through the patent quagmire and get a patent on a software design, you need to consider designer rounds during this interim freedom to operate review. And it's at that point that you can make those changes to the product specifications, to the product design, and come up with a product that is a design around. If, on the other hand, you can't find a design around possibility, you need to do a deep dive into the validity analysis. So what are the elements of these kinds of opinions? And of course, we have freedom to operate opinions, we have informal reports, we have secondary freedom to operate opinions, we have formal non-infringement opinions, formal invalidity opinions, we have memos about the same, and they run the gamut from simple email discussions to memos to a full bells and whistles address of the issues. When you analyze these patents, whether it's a freedom to operate, whether it's an informal report, non-infringement opinion, a survey, you always need to remember that the analysis is in two parts. Two parts. It's universal. First is interpret the claim language. And the second is apply the interpreted claim language to the product if it's an infringement, or to the prior art you found in case of validity or invalidity. And by applying the interpreted claims to the product, you will also be able to see how you can come up with design arounds, because the properly interpreted claims will give you a hint, or maybe will give you a bright light to indicate what changes you could make in your proposed product to come up with a design around. Similarly, in the validity invalidity situation, though properly interpreted claims will help you identify whether you have a strong invalidity position, a 102 anticipation position, or whether you have a weak obviousness position. And it will give you information about whether you should proceed or not, and what kind of litigation problems you're going to run into down the road. So this kind of analysis applies not only to potential defendants, but it also applies to the plaintiffs. And as I said before, in the plaintiff situation, where the plaintiff thinks that somebody is infringing his patent, he needs to do an opinion. It doesn't have to be a full-blown 110% bells and whistles kind of opinion, but you need to satisfy Rule 11. Also, the plaintiff, the patent holder, is well advised to consider patent validity before going ahead with the patent. And as we've seen from the patent office considerations of IPRs, inter-parties reviews over 60% of the time for pharmaceutical patents and chemical patents, and for a higher percentage for software, electronics, and mechanical patents. Those patents are, claims of those patents are invalidated in the IPR. So it's a good idea for the plaintiff to have his own patent validity study conducted before the plaintiff thinks about advancing that patent in an infringement case, because patent validity can always come back to bite the patent holder. So interpretation of claims. This is probably one of the most difficult areas of this kind of practice, interpretation of the claims. Now you might think, well, hey, interpretation of claims. What does that mean? Aren't you supposed to read the language of the claims, and it's supposed to have its plain, ordinary meaning to one of skill in the art? Yes, those are the buzzwords. And of course, those are the buzzwords in Phillips, which is the way that the federal courts are to look at claim interpretation. And in the patent office, of course, it's the broadest reasonable interpretation based upon the words themselves in the claims, and to some degree what's in the specification, rather than what the plaintiff has, or what the patent holder has said during prosecution and what's said in the cited prior art, unlike in Phillips. However, I caution, as many of you probably already know, the PTO has proposed a rule change, at least for the PTAB IPR rules, to put the claim interpretation for IPRs to make it consistent with what the courts see as claim interpretation under Phillips. Whether this is a good idea or not remains to be seen. My personal view is that this is a lot of smoke with actually no fire, because when you actually look at the cases coming out of the PTAB and their claim interpretation, you realize that almost all the time, not invariably, but almost all the time, or maybe not even almost all the time, but pretty much a majority of the time, the claim interpretation under the broadest reasonable interpretation winds up to be about the same thing that you would find under Phillips. So let's talk about a case here involving claim interpretation. This is a pretty simple one. Claim interpretation, though, is tricky and subtle, as indicated by this Teva Pharmaceuticals versus Abbott. And here, the claim is very simple. It's an isolated crystalline antibiotic, which in crystal form has molecules of this erythromycin, and a solvent molecule. That's what the S in this figure is, a solvent molecule. And the particular solvent that the defendant was using was ethanol. So the question is, ethanol, we all know what ethanol is. We drink it. It's C2H5OH, but that's not the whole story. When you read the rest of the patent, you realize, wait a minute, ethanol, what kind of ethanol are we talking about? There are many different kinds of ethanol. There's absolute ethanol, which is ethanol denatured with benzene, so that it's only ethanol. There is the ethanol eutectic form that is 95% ethanol and a little bit of water. There's ethanol from which there's absolute ethanol from which the benzene has been removed, but if you have 100% ethanol and you put an open beaker of that ethanol out on the table for 2 minutes, it pulls water in from the atmosphere, and so it is diluted. And so the question here in the litigation, it was a difficult question, is what kind of ethanol is needed for this crystalline form? And it turns out in this case that depending on the kind of ethanol, whether it was ethanol with a little bit of benzene, ethanol with a little bit of water, ethanol with another kind of alcohol like isopropanol, ethanol that had been denatured in some other way, the crystal structure was different. So here, claim interpretation of that simple word ethanol, which we all know what it is, was a very difficult topic. So that's why claim interpretation is tricky and subtle. You need to do a deep dive into some of these words that, at least on their face, appear to be understandable in order to make sure that you understand what that claim is really about. So rules for infringement analysis. That's another part of our consideration here. And once you have done the claim interpretation, you need to look at infringement analysis. And so for the moment, we're not going to talk about invalidity and invalidity analysis. We're going to focus now only on infringement analysis in these situations involving the plaintiff and the defendant, where the defendant is infringing the claim, is alleged to infringe the claim. There are two rules for infringement analysis: the literal infringement and doctrine of equivalence. And there are two rules involving these: the all elements rule for literal infringement and the all limitations rule for doctrine of equivalence. And of course, once you've done the claim interpretation, you look to see if the claimed product has each and every appropriately interpreted element written in the claim. That's the all elements rule. And if one of them is missing, then of course the answer is simple: you don't literally infringe, the all elements rule. But if one of those elements is missing from the accused product, you then have to turn to the doctrine of equivalence, and you ask the question, are the all limitations rule satisfied? Now, to do this, you look at the intrinsic evidence, the specification, the file history, the cited prior art, to determine what's going on here. And so the depth of analysis and explanation depends on what kind of situation we're talking about. Bear with me just a minute. So organization of the formal opinion, of course, the literal is, as I said, is straightforward once the term interpretation is done. And doctrine of equivalence is always difficult because there is a penumbra, as Judge Learned Hand described it, the penumbra between literal language and the prior art. What is it and how far does it extend? This is the analytical distance between the literal elements of the claim, the analytical distance between the literal elements of the claim and the product. So in these situations where you have an FTO or an informal report, of course you need to address literal infringement and doctrine of equivalence. But your depth of explanation will depend on the need for claim interpretation and the nature of the opinion. It's the analytical distance between the product and the claim. So in a situation involving an informal report or freedom to operate, where you're not looking down the barrel of a charge of infringement or a possible charge of infringement. Instead, you are providing assurance to your company or to your financial supporters that you are free and clear of patents. You don't need to do a deep dive into the analysis involving the doctrine of equivalence if the analytic distance, I should say, between the product and the claim are large. And so if, for example, your product is completely missing one of the elements required for literal infringement, and then you look at the doctrine of equivalence and you see that, you know what, there's no substitute in my product for this missing literal element, well, then you don't need to do this deep dive, and it's a fairly simple opinion to draft to explain. On the other hand, if you have something in your product that could be argued to be a substitute for the missing literal element, then you need to do maybe a moderate dive, maybe a deep dive into the analysis of that element, because the analytic distance between the product and the claim is very small. So that's the story about freedom to operate situations where you're trying to provide assurance to your corporation, to your company, to your financial investors that you will make all these developments, you will invest all their money, you will invest all the time and effort of the researchers, and you won't be blocked at the end by patents. On the other hand, if you are in a formal opinion situation where there's a threat of a litigation, for example, someone has sent you a cease and desist letter or a warning letter or even an innocuous letter saying something to the effect, hey, you need to take a look at my patent. I hear that you have announced you're going to start selling your product XYZ in a couple of months, and I think that you need to look at my patent. Of course, this isn't a cease and desist letter. It's simply a notice letter. It's not even a notice letter so much as it's an awareness letter. And the thing is that once you have that kind of letter, you can't say, I didn't know about that patent. And so I'm not in a situation where I'm going ahead and nobody can say I'm willfully infringing this patent. You do know about the patent. And so this is a situation where you need that formal opinion. And why have one? That's from outside counsel. It provides good faith effort towards avoiding infringement. We're back in the situation involving the halo situation and the risk of treble damages and a demonstration that you are not willfully infringing. You have a competent opinion. So what is inside a formal opinion, an FO? It's a full two-stage analysis involving claim interpretation that's fully written out, involving all aspects of the all elements rule in a literal situation, of the all limitations rule in the doctrine of equivalence situation. You need to address those in writing, and most important, you need to make sure the analysis is sound. It's not conclusory, but you provide a connection between the beginning and the end, and you connect all the dots explaining how you get to the end conclusion. And of course, in these formal opinions, you need to address other aspects of the situation involving marking, for example, written description of the patent, indefiniteness, latches, inequitable conduct, the Lanham Act, fair dealing, contract issue. All these things should be considered, at least, if not addressed in that formal opinion. So the organization of the formal opinion, I suggest to those who ask me, it should be organized kind of like a Federal Circuit opinion. You need a section on the law. You need to say who is going to be a person of ordinary skill in the art, a posta. You need to incorporate case law discussion into the walk the line sections of analysis. Walk the line sections of analysis are those situations where the analytical distance between the claim term, the properly interpreted claim term, and the product are very close, and you are trying to walk the line steering towards non-infringement. So you need to provide case law explaining how you're able to walk this line, and you need to provide a very clear, detailed discussion of that kind of factual analysis. So the important factors here for the formal opinion are all elements, all limitations, and you need to, for the all limitations, you need to use the Federal Circuit law for scoping out the penumbra for the doctrine of equivalence, the file history estoppel, claim amendment, file history argument, common sense, and the scope of the term interpretation. Now, there's a trap here for those of us who are writing formal opinions for potential defendants, and that comes in the scope of term interpretation. We know where the defendant wants to be, yet when we interpret those claims and those claim terms, the requirement is they're to be interpreted without looking at what the potential defendant has as a product. And of course, since we already know what the product is, we will all have a tendency to try to interpret those terms in a way that will give us some wiggle room for showing that there is not an infringement, especially under the doctrine of equivalence. But of course, this applies to literal infringement as well. So this is a caution for those of you who are writing opinions, that term interpretation has to be done without a prior knowledge and view of what the product is supposed to be and how the product relates to the claims. Very difficult to do, and you need to keep asking yourself, you need to second guessing yourself in this situation, saying, am I being biased? Am I slanting this description towards a way that I want to get to, which is not the right kind of analysis? And of course, if you're in a litigation and you as the opinion drafter are questioned about this, and you've got a sharp New York lawyer who is examining about your term interpretation, and it becomes clear that when you interpreted those claims, you were interpreting them with a view towards the product, you're going to have trouble. Above all, in these opinions, do a well-reasoned analysis. Do not provide conclusory remarks alone. And as I said in the beginning of this discussion, we all have opinions. We can all say, oh, my product doesn't infringe that patent claim. Explaining why is the important thing, because in a litigation situation, you're going to have attackers saying, no, you're wrong, no, you're wrong, no, you're wrong. And so you need to have a well-reasoned opinion. You may have a good faith, well-reasoned basis for saying, oh, no, my product doesn't infringe that patent claim, but you need to explain that in writing. Okay, folks, that's the end of my discussion about the history of HALO and the resurgence of competent opinions. And what we need to do now is answer some of these questions. And let me see here. Do we have? Okay, let's see. The first question: how do you address one-on-one? How do you address one-on-one issues in an invalidity opinion, particularly the presumption of validity versus the current case law that has deemed one-on-one to be a legal determination, which would mean that there would be no presumption that the patent is directed to patentable subject matter? Very interesting kind of question. Well, of course, in an opinion, if there is a one-on-one issue, if it's a natural product, if it is a mathematical equation, if it's a software that is susceptible to an Alice analysis, yes, you certainly should address one-on-one. But we're talking about issued patents here. We're not talking about patent applications, and so there's a fine distinction here in one-on-one situations involving patent applications that are facing one-on-one issues and issued patents. And here we're assuming that the patent has been issued post-Alice and and post the pharmaceutical cases, the Mayo cases, and all of these cases that concern 101 and the Supreme Court's decisions about what constitutes invalid subject matter or non-patentable subject matter. If the patent has been issued subsequent to all those cases, then of course 101 has been examined and the patent has issued, and so the patent is presumed valid. Yes, you can prove the patent is invalid with a 101 discussion if you can win that in court, but nevertheless the presumption stays. Now, if you have a patent and it's an old patent and it was issued before all of the 101 controversies came about, you still have to address it. You can't presume that the patent is invalid. You're going to have to prove that the patent is invalid with a competent, well-reasoned opinion, just like you would need to do post-Alice and post-Mayo. So it doesn't change the kind of opinion that you would need to write in an invalidity situation, especially because the patent has already issued. Okay, next question. What kind of opinion, if any, should you get if you find an open application that might disclose your invention in the specification but does not claim it? I'm assuming that by open application means that there's a patent, well, a patent that has a specification describing your invention, but doesn't claim it. That's one situation. Second situation would be a published application which discloses your invention, but at least the claims in that application don't cover the application. Okay, so those are two very distinct and very different situations. In the first one, where the patent is already issued and it discloses your invention but does not claim it, of course, if it discloses your invention but does not claim it, you've still got an anticipation problem, because that's a disclosure. If it's not an anticipation problem, but it's an obviousness problem, you've still got a problem with your own invention. Second point is, if there are no continuations or family members of this patent, then presumably the patent holder cannot go back and assert claims to that disclosed but unclaimed invention, and so you are free and clear of going ahead and selling your product. That's let's see, what's that case? It's the Shuutai case. I don't remember the name of it right now, but it's the old Shuutai case, the Federal Circuit case, where there was subject matter disclosed but not claimed in the patent. In a published application situation, you are in danger, because in the published application situation, the patent or the application holder can file continuations to pick up that disclosed but unclaimed subject matter. So you need to be careful about that. I'm assuming here that you think your invention is patentable and you want to go ahead and get a patent on this too. And of course, in that situation, you're probably out of luck, because I'm assuming that this published application has a filing date before you, and you probably haven't filed your application yet. So under the new rules, first to file wins the situation. So you need to keep track and run a survey and continue to monitor that published application to see if there are any subsequent continuations or divisionals filed that would claim your invention. What do you do about it in a situation where you find a patent application later on that's a continuation or division and does claim your invention? Well, if you're committed to selling that product, your invention, you're going to have to figure out some design around or some fix of your invention so that you avoid that patent, or alternatively, try to figure out an answer to the question of validity, try to invalidate that patent. Okay, third question. Can you explain any difference between an element and a limitation? Yes, well, an element, of course, an element, that's the all elements rule. That's the literal infringement situation. And the element would be the words of the claim, all right? Words of the claim. So if you say ethanol in our claim interpretation example here, if the claim requires ethanol and you don't have ethanol, but instead you have, say you have benzene, okay? All the possibilities there were alcohols, I believe. If you have benzene, then quite clearly you don't have ethanol and you don't have anything else that literally meets exactly the words of those claims. It's not ethanol, it's not isopropanol, it's not butanol, it's benzene, and benzene isn't an alcohol at all. Okay, limitation. Limitation is a fuzzy concept, okay? I can't overemphasize this. Doctrine of equivalence is fuzzy. That's why I use the word penumbra. That's why I said analytic distance between the claim language and the product. It's fuzzy. And that's what I mean by limitation. It's fuzzy. So here in our situation, we're talking about alcohol versus benzene. Now, those are two very different kinds of products or solvents, really. One is hydroxyl and soluble in water. The other is not. There may be some circumstances where benzene acts as a reasonable substitute for ethanol in this same situation. And you might be able to, or the plaintiff, the patent holder, might be able to find that kind of explanation in the specification and in the cited prior art and under the doctrine of equivalence, also in uncited art, explaining that these kinds of macrolide antibiotics can form solvates. They'll form solvates with alcohols. They'll form solvates with hydrocarbons like benzene or hexane, and unless there's a prosecution limitation that eliminated benzene from the discussion and from the possibility of including it as a solvate molecule in this crystal, then that word limitation might, under the doctrine of equivalence, mean that your benzene would be covered. I doubt it, but you see, that's the point about the doctrine of equivalence and all limitations, is its fuzziness. And that's the difference between element. Element is it or is it not? Is it what this word says or not? Limitation, under the doctrine of equivalence, all limitations means, okay, I don't have exactly what it says, but do I have something else that meets the overall limitations of the concept of this claim? And of course, we're focusing on the missing element and what that element does for the overall product being described in this claim. And that's the fuzziness involved in limitation. Okay, next question. Aren't opinions needed in foreign jurisdictions as well for products with some global relevance? Might be worth mentioning. Aren't opinions needed in foreign jurisdictions? You know, it's interesting. Yes, opinions are needed in foreign jurisdictions, but many foreign attorneys tell me that opinions aren't as worthwhile in foreign jurisdictions as they are in the United States, because there aren't such things as treble damages as a statutory requirement or statutory possibility in foreign jurisdictions. In addition, in foreign jurisdictions, not all jurisdictions, but in some jurisdictions, the patent holder and the jurist, the judge, or whomever is looking at the patent from a litigation point of view, can rewrite those claims, which of course is unheard of in the United States. We do that through the patent office reexamination process, but we don't do that in court. And so in foreign jurisdictions, yes, opinions are needed, and opinions certainly, from a company point of view, help the company understand whether there's a risk factor and how great the risk factor is in going ahead and developing a product. But in terms of treble damages and whether the opinion is going to have influence on the court or not, it's not as important in foreign jurisdictions, at least I understand, as it is here in the United States. Well, I want to thank all of you for listening to my discussion about opinions, and I'm available for consultation, or if you have further questions, please go ahead and send me those questions. I'll be happy to answer them.
Thanks, Jim. Thanks for taking the time today and giving some piece of education on opinions. I'll be sending out a copy of the slide deck and the recording by tomorrow morning to everyone, so look out for that email. If you have any questions, feel free to contact Jim directly. Thanks again for joining, and we'll be in touch soon. Bye now.